Hello everyone, welcome to Court with Krissy. I've got back-to-back small claims cases, and boy, are they both fun. Just wait until case number 2. Don't worry though, I'm pretty sure he was just going number 1. I hope you like it. Court with Krissy is now in session.
All right. And so this is file
Jim, you gotta turn your
2500.
microphone on.
What's that, ma'am?
Jim still don't have his microphone on, right?
No, he's just got himself muted. I'll handle how the court
Okay.
works, ma'am.
All right.
Don't
fine.
address the other parties directly.
Okay.
This is file 25000309SC, Candlelight Condominiums versus Tibbetts. Parties are here for a small claims case. What that means is we're trying to get this done without any attorneys. Nobody is represented by a lawyer at this time. We are also trying to get this done without any thing like a jury trial, but for this just to be decided right here in front of me. And so with that being said, seems like this is pretty straightforward. Oh, I pulled up the wrong case. Hold on one second. That the on behalf of the condominium association, Ms. Behrens, what is it you do? I'm
the president.
Okay, I just need to make sure you can answer for that. And so essentially this is, I understand past dues, and then what I don't know about is finance charges. I'm assuming you're charging something for late fees.
Yes.
You're allowed to do that as long as it's reasonable. Right. I just don't have that listed. So Mr. Tibbetts, part of you living there is that you have homeowners association dues. All right. And for some reason now they're suing you because they're saying you're not paying your homeowners association dues. So my first question to you, what's that?
I have been paying my dues ever since I moved in here, except on the rare occasions when I paid them and they've lost them.
Well, I'm not sure we get to $1,269.50 on lost homeowners dues. Ms. Behrens, approximately how many times has he not paid his dues?
I don't know that he hasn't. He has other charges on there for things
because you didn't send it to court, right?
Right.
So I don't know what you're looking at, ma'am.
I'm looking at his statement.
Yeah, it would have been a really good idea to send the statement in as your proof, because now's the day we're here in court and you're just telling me he owes this money. I have nothing. And he's telling me, no, I pay my dues except for when they lost them. What are the homeowners association dues?
$80 a month.
Every
month.
So approximately how many months has he not paid?
Like I said, I don't know that he has not paid. I'd have to look it through, but he has other charges on there. And I've never had
what?
To send it. Like I said, he didn't take care of his yard and so on. So
okay. So you have penalty charge. I just assumed it was not paying homeowners dues. That's the most common variety. So why don't you spell out of the $1,269.50? Tell me what it is he owes for.
Well, there's the $675. That must have been for cleanup. We actually cut a tree down, but it was only part on his, so we paid for that. That was $2,000. And he is.
Ma'am, I don't need you to tell me things I don't need to know.
Okay, sorry.
You didn't send in the evidence. I just need you to tell me, what is it that he owes for?
Well, that's the $675, and he's being.
What is that charge for, ma'am? And when is it from?
It's from October of 24.
Okay, and what is it for?
It's for cleanup of his yard.
So you actually paid a third-party service to go in and clean it up?
Yes.
Is that in your homeowners association bylaws?
Yes, we go through
and what triggers your ability to do that to him?
We have stated, we give them notices, we're going to go through for yard checks once a year. And we go through yard checks, we have a list, and what isn't taken care of, we give them a list. And they have 15 days to take care of it or contact us, and that hasn't been done.
All right. And so you contacted or notified him that
Right.
his yard was on this list.
Right.
And then he did nothing for 15 days.
Right.
And then you hired a third party to come in and clean it up.
Right, right.
All right. That's 675. What else?
Okay, and the painting of his shed and so on, we aren't gonna do that. So he gets $50 a month charge for that. And then there's.
And that's spelled out in your bylaws that if you don't paint your shed, it costs $50 a month.
Yep, it has to be taken care of, yep.
And then that has not been paid since when? Or not been painted since when? When did you inform him that that was going to start accumulating a $50 a month charge?
That was last summer when we went through the yard check. Before we did the.
Okay, so how much does he owe for not painting the shed?
It's $50 a month.
Ma'am, you cannot just keep saying that.
For that.
I'm not going to sit here and add up the months for
Oh.
you. Tell me how many months
Okay.
that you are charging him for not painting the shed that you get to a number.
Okay, we've never had to do it this way, but I would do it. Okay. One,
Ma'am, you've only ever sued one person
350.
one other time in front of me, and that was for dues. So don't tell me you've never had to do it this way.
Okay, it's $350.
All right, so that's $350.
That's through February.
That's $1,025, so keep going.
And then there's the interest. And that's all like $1 something every month. And that's been going on.
What is your percent interest that you charge?
It's 5.5%.
Okay, that's reasonable. So how much do you have in interest?
I'm sorry, I didn't know I had to add that all up.
Well, ma'am, what did you think was going to happen? That we just go by the total number?
Yep.
And that he
Yes, so.
doesn't contest it item by item? That
This
doesn't
first
make a
time
lot of sense to you, does it?
I don't have an answer for that.
Yes, ma'am. Do you know why you don't have an answer to that?
Because I wasn't told I had to do that.
No, ma'am, because 5% interest to get to $255 on 1,000, that is not 5% interest, ma'am.
It
That's
goes
a lot
back.
more than 5% interest. Your math is bad.
Okay, there's also charges back in 22 and 21. It goes back. There's $50 charges way back. If you need me to, I'll send you the statement and.
Are you gonna send it to me in the next 30 seconds? This is the time and place for you suing him. When did you think was a good time to send the information to me so that I could look at what you're suing him over?
Well,
how did you think this was going to work in your head? I'm just curious. That you'd come here and then I would just say you must win because you're the plaintiff?
No, I'm sorry. I'm ignorant on that part. I've never done this part before, so I'm sorry. I don't know what else to tell you.
Mr. Tibbetts, so here's
Yes.
the problem. If you choose to buy property where there's homeowners association, they can make bylaws and then you have to live by those bylaws. You may not like them, but as long as it's spelled out in bylaws that if you don't clean your yard up, they're going to charge you to have somebody come in and do it. You're going to have to pay that money. Same with if they decide your shed's not painted right.
Yeah, I'm wondering, one, I didn't know that it was $50 a month on the shed bit. And how do you paint over the winter time? But
It was in the summer we did that.
Well, you said it over February. Also, since April 29th,
Wait,
I've
Mr.
been
Tibbetts, this is
disabled.
important. Are you telling me you were never made aware that you were supposed to take care of the shed and that you were going to get charged $50 a month?
I knew I was supposed to take care of the shed, but since the end of April of last year, I've been disabled. I've had a serious fall and fractured my spine. It was not able to do a lot of stuff because I was walking with a cane and bending down. I'd have been picking myself up off
All
the
right.
ground.
Now, sir, that may very well explain why you didn't do it, but it's not a legal reason why you don't have to do it. You understand?
Yes, I do.
Okay.
One of the board members lived right next door to me, and she knew that I had had the serious fall and was not able to do stuff.
So
And like
here's
I
my
say,
question. Do you
I would
believe
have
that
done
you
it
owe
if I could have.
Do you believe you owe the
That's-
homeowners association money?
I owe them some money, but not that much. That's
Okay, what do you think you owe the
$675.
money for?
You know what that cleanup of the yard is for $675? They had a person come around with a gas powered hedge trimmer and cut down everything around within a couple feet of the house foundation, and they spent less than an hour at it. They picked it
And
up and
sir,
left.
if you had paid someone to do it, maybe you could have had it done for $50, but you chose not to take
If
care
I'd
of it.
had
You forced
with
them to
the
take
fact-
care of it, and $675 is what they got charged.
With the fact that I was disabled, I was not getting any income. I
Okay,
received.
sir, again, that is a good
social-
reason why you're not taking care of these things. But for me, it's not a legal reason for them not to be able to charge you.
And also the statements they send me, all it has on there is an invoice number and an amount. I've been trying since back and first started to get them to explain what the stuff is for. That $50, whatever, back then, I've been trying to get them to explain what it's for. And all they
Are
ever
you
send
telling me
me,
you've never had
is
a
this.
conversation with Miss Behrens about this?
No, I haven't. I've sent things through dropping notes that they have a drop box down at by the mailboxes.
And okay, were you ever
there
contacted by them to have them explain it?
No. All they've
All right,
ever sent me
then
is a
hold on a
paper
second.
with an invoice number and an
Miss-
amount, and they won't tell me what the invoice is
Then hold
for.
on a second. Miss Behrens, if one of the people in the homeowners association were to go to the Dropbox and say, hey, I'd like an explanation before I pay this, what do you do about that?
I would talk to them, but I've been going to the Dropbox, actually taking care of the treasurer's job too, since May, and there's been no notes. But the invoices that are sent to him, I have a copy of the one from February 11. It's $50. It says fine for shed needing painting, and he still had weeds around the shed, growing on the shed.
All right, so the invoices do have some sort of explanation on them.
It does,
All right.
it's on there. Every month.
All right. Here's the thing, and like I said, there may be some old charges on there, but you're not quite articulating them. I have $1,076.25 worth of stuff that you've articulated for me that makes sense. The yard cleanup, 5% interest, 5.5% interest, and $50 a month for $350 worth of, hey, you got to take care of the shed and you didn't. Would you like to add anything else to there? Because that's about $200 shy of what you asked for.
Well, he's gonna be charged another $100 and some this month, but that's fine.
All right.
We'll just bill him.
So I would make a finding here in damages in the amount of $1,076.25. Mr. Tibbetts, I also need to explain to you that the condominium association paid certain monies out of pocket to get here today. They paid a filing fee to court and they paid to have you served. That was $121.15. They are also able to recover that. So I just wanted you to understand where that extra money comes from. Now, here's what I need you both to understand. Either one of you could say, I disagree with what just happened there. I want to appeal this verdict and go in front of the district court judges for general civil. To do that, you must do two things. One is you must ask for that within 7 days of today's date. Your opportunity to contest this further ends after 7 days. And two, you must come in and do that in writing. You can't just ask for it over the phone. So I just ask you one at a time. Do you both understand your rights on appeal?
Yes.
Mr.
Yes.
Tibbetts? All right.
Yes.
So we're all set for what we need to do here today. I'm going to release parties. Ms. Behrens, I am going to talk to you just for a second because I'm assuming that the other message I got on the Candlelight Manor case, you're also involved with.
Yes,
I think it was the person you sued last time.
Allman.
The problem is the court does not do collections. So I know that you guys had some arrangement worked out and you're saying he's not doing it and he said they're not letting me do it. But just so you know, the court does not do collections. We would not involve ourselves in whether or not the judgment is satisfied. You have a judgment against them. You
Right,
can file paperwork to do things like seize tax returns or garnish paychecks. But you can't just write a letter to the court saying, hey, he's not paying, make him pay it. That's not a thing, okay?
okay. I was told that by when I called the court, so that's fine.
But there are other things you can file that have a
Okay.
little more teeth as far as like trying to get that money. But just to let you know, in general, the court doesn't go near collections. Once we make a ruling, a judgment, that means they owe you the money, but we do not enforce them paying you. Does that make sense?
Okay, okay.
All right.
All right.
I'm going to go ahead and release you. Thank you.
Now on this one, on Tibbetts, I can say I don't agree with it. I have to send something in. How do I do that? Because that's over $400.
You'd have to come in and fill out the paperwork to appeal to the general civil. And you got to do that within 7 days.
Okay,
And then you would start all over again in front of the district court judges.
all right.
Thank you. Ooh, doo, 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 doo.
Okay, do we have both sides on the Bears Den Gallery versus West Bay Shore Village?
Yeah, good morning. Bear Den is here.
Okay. Is West Bay Shore here?
Yes, I'm here. Hold on, I'm in the bathroom. I apologize.
Okay, just take your time, sir. You're in open court, so.
Apologize. I apologize. I was in the bathroom.
It's no problem. Okay, it's no problem. Let's just not worry about it, okay?
Okay, good.
Okay, and you're on your phone, I assume?
No, I'm on my laptop.
Okay, so I don't think you have your video going.
Okay, let me see.
Sometimes sometimes your camera just might be covered.
No? Let's see, Richard Van Steenis. Okay, video. Oh, I see it. Okay. Yeah, I'm kind of new to this. How do I turn that thing on? Okay.
And
Desk
we
view.
don't really,
Still says, yeah.
and if you can't get the video going, that's okay, because we can, as long as we can hear you.
Okay. Well,
We can,
I'm clicking there is a red line across video on the bottom, and I'm clicking it, but it's not offering the opportunity for me to get rid of that red line. Oh, there it goes. Well, okay,
Usually
now
there's
it's pinging on my phone. There I go.
okay,
How's that?
good.
See,
It's fine. You can see your ceiling.
all right, and now I need to think I turn it around here. Let's see here, because what you're getting is the wrong side. So that has to be like, okay, how do I turn the camera around? Oh man, I've never done this before, so I appreciate your patience. I just can't turn the camera around now.
It doesn't matter as long as we don't need a video necessarily.
Okay.
We can do it with audio. So
All right. Well, I guess I'm fine then. Let's proceed.
okay. So this is a time set for a small claims hearing.
Correct.
And okay, now it's your turn to listen, sir. Okay.
Oh, I'm sorry.
Please.
Okay.
That's okay. This is the time set for a small claims hearing. And in the small claims division of district court, you have less rights than you do in the general division of district court. In the general division, you can sue up to $25,000. You can hire an attorney in the general division, and you have the right to appeal in the general division. So no matter what the decision may be today, you don't have the right to appeal in small claims division. So if either side wishes to have this case removed to the general division of district court, we can do that at this time. Does the plaintiff wish to go forward today, or do you wish to remove?
Wish to move forward in small claim.
Okay, and does West Bay Shore wish to go forward today, or do you wish to remove it to the general division?
I would like to move forward.
Okay, and are there going to be any witnesses other than the two of you?
Not from Bearden, no.
Just myself. My
Okay,
wife's not
good.
here.
Okay, so I'm going to ask you both to raise your right hands because we're going to swear you in, okay? Do you swear or affirm that the testimony you give in this hearing will be the truth, whole truth, and nothing but the truth?
I do.
Absolutely.
And defendant? Fair.
Yes.
Good enough. Okay, and so, to start out with, there's an agreement that's been signed by the parties. And does the plaintiff agree that you are entitled to $1,000 because of that agreement, or are you seeking your money out totally outside of the agreement?
$1,000 relates to that specific term of the agreement. Yes.
Okay, then let me ask the defendant, does the defendant agree that $1,000 is owed based upon that agreement?
No, I don't agree.
Okay. Okay, and why don't you agree?
Okay, well, the issue has been always about, that early on in our agreement, Jay was looking for a way to get out of the last part of the lease, which is the last 4 months. And we wanted early termination based on that. It was just, we're having, difficult communication. Things weren't working. I know his struggle, the struggle with his business. They had a new baby this year. There's just a lot of stress on them about keeping the business operating on an hourly basis. So there was a lot of tension. And so we allowed him to terminate his lease 4 months early with no recourse. The only condition, as far as I was concerned, was that we would help him, recapture the front yard where we wanted to go in and make that back to where it was originally, because we had given him the use of the front yard. And so that started the process of just early termination. And the agreement, as far as I was concerned, was that he would to remove all of his personal items and fixtures out of the space, which is what he didn't do. So he didn't fulfill that obligation, and left an incredible amount of work for us to complete our early termination. So I had to hire people to go and clean it up. And it was not part of our original agreement, which was a lot of a handshake also, was that, the agreement was he's going to just make sure he got his personal items out of the space along with his fixtures. And he literally walked out the door and threw the keys on the counter, and that was it. And so when he came looking for his $1,000 damage deposit, I said, Jay, this is doesn't work for us, not based on our agreement. So that's really the gist of it. We wanted to, help in any way we could. We knew that they wanted to close their retail space and of course, keep their business online. So we wanted to help them do that. And it ended up costing us a lot of money to do this early termination. And I just don't see where he feels, $1,000 a damage deposit makes sense. So
Okay.
he's been, and we tried to negotiate. But of course he has, all these other fees that he's now tacked onto that, and it just seems, our family's been in business on this property for almost 50 years, and we've had some wonderful tenants through our entire, and plus we run our own business out of this space. So we have a direct contact with with Deborah and Jay. And of course, since the baby's come, Deborah's no longer been part of the business and Jay's taken over to kind of terminate the business. So, you know, our upset has been that it's just one conflict after another with Jay and his desire to early terminate. So that's
Okay, you know, let's stick to the facts if we can, as opposed to what you may think is
Okay.
happening, okay? So you did sign an agreement. The agreement says you pay, he gets $1,000, right?
Correct. If he, you know, removes his personal items and his fixtures.
Does it say that in the agreement?
Well, that's sort of standard operating. You know, we had a handshake about him just, you know, vacating the space and taking everything with him. So that's just not, you know, I mean,
Okay.
I didn't say that he had to, you know, shampoo the rug or fill the holes or anything like that. It's just sort of, you know, when landlords go into, you know, a good standing lease agreement, it always is about people removing their stuff because the next tenant, you know, we've got to prep the space for the next tenant. And that's really the issue.
Okay, and that's, you're from the plaintiff. Now, there's
Myself.
an agreement, where the plaintiff is supposed to receive $1,000 and you're suing for an additional $553.41. So explain to me how you get beyond the $1,000 agreement.
We were looking at, in addition to the $1,000 agreement, prejudgment interest, and then as well as court filing costs, legal fees, etc.
I understand, no, but if, I think you're asking for $553.41 in
That's correct.
damages.
Let
Okay,
me,
talk to me about those. How do you get that?
sorry, my Excel version just froze here just a moment.
It's okay. So I think you're claiming for damages in excess of the agreement.
Correct, yeah, so damages in excess of the agreement, we were looking at prejudgment interest beginning the date the $1,000 was due.
Let's not worry about the interest, okay, at this juncture. What?
Oh, I'm just summarizing how I reached that additional 500 some odd dollars. So that would be included in that 500 some odd dollars. So separate of that, we have the court cost filing fees. We have the 2 hours of legal research time.
$86. You have $86 in court costs. How are you damaged in excess of the $1,000? Okay.
So the damages in excess of $1,000 that I would seek would be relating to the time and the effort related to constructing the claim, doing the legal research, communications with the defendant, and travel to and from the court for filing.
Okay, and why do you think you're entitled to that?
I would otherwise not have experienced those costs, that time, and those monetary expenditures if it weren't for the defendant's lease or the breach of the agreement.
Okay, anything further from the plaintiff?
Yeah, just out of respect to everybody's time, I feel this is like a very open and shut matter. To, I guess, respond to some of the claims that the defendant is making to refute his expenses relating to our early termination. The early termination agreement was sought by the defendant, and there's the attached screenshots of text messages that I attached as evidence that he requested the early termination and release agreement as he was facing legal exposure and real monetary exposure following damaging our property, our furniture, fixtures, and equipment, and his breach of the lease agreement. In light of those potential and real costs that he was facing, we entered into this early termination and release agreement, whereas we would forgive those monetary expenses and forego any potential further lawsuits relating to his breach of the original lease agreement. As if we look at early termination lease section 1, the landlord immediately assumes responsibility for maintenance, repairs, cleaning, disposal, or other restoration of the premises. in the negotiation for that early termination agreement, it was explicitly stated to the defendant that we would not pull a single nail, we are not sweeping a single floor, we are not removing any items, because those costs would offset his real cost that he owed us prior to entering into this agreement. So this agreement both had, mutual considerations. He had time to consider it, even in the text message exchange and the screenshots that I attached. We had 2 iterations. So for him to state that he does not understand the terms of this is kind of wild to me. He had an opportunity to review it. He provided feedback. We modified the agreement per his feedback, and then we executed. For him to state also that there's other agreements and handshakes and negotiations outside of this agreement, Section 9 of the agreement clearly states that's not the case. This agreement supersedes all agreements, understandings, negotiations, and discussions other than this release agreement. So out of an abundance of respect for the public's time, we do greatly appreciate, the opportunity to come in and present. But I feel this matter is very open and shut.
Okay, well, my time is your time today, okay? So it's okay. So, okay, anything further from the defense?
No, like I said, we wanted it to be a smooth transition, and it was very difficult to say goodbye to Bear Den. They were with us for 6 years, and it was something we had never experienced before. And the litigious side of this is just absolutely absurd. We could have just, like we spoke, do what we say we would do. And that's exactly, how this all came about. Needing to do an early termination agreement was in my case, I felt that it was sort of under duress. We felt just completely assaulted by Jay's accusations of what our character's all about. We've been business people in Leelanau County for almost 50 years, and we always treat people with the utmost respect and encourage them to be good business people and have and this just got out of hand litigiously, and I just feel Jay takes advantage of that versus just being the kind of person that everybody wants to work with. And so it was really a difficult end of relationship.
Okay, well, but the relationship did end, right?
Correct.
And you did sign the agreement, correct?
I did.
Okay. And you realize the agreement requires you to pay $1,000?
Well, what it actually, my understanding when I read it is that at the end of our relationship, and he's basically gotten his stuff out of the place, yeah, our relationship is complete.
Okay.
And so that was the issue as far as I was concerned, that he just didn't remove his stuff. I mean, his sign is still hanging.
If I could interrupt, doesn't the agreement say tenant shall have no further obligation under the lease? And wouldn't that cover everything that you're complaining about?
Well, as far as I was concerned, no, it didn't. I just, looked at.
Well, let me read it to you, and
all right,
because maybe you missed it, but tenant shall have no further obligation under the lease dated January 1st, 2022, and subsequently modified and extended November 2nd, 2023, including but not limited to rent, utilities, maintenance, repairs, cleaning, disposal, or other restoration of the premises. And that's pretty much what you're complaining about, isn't it?
well, no, I'm not complaining about the cleaning. We figured we would have to clean up the space just for
How
him
about, how,
move.
how about the restoration of premises? Isn't that what you're complaining about?
No, I'm not at all. I'm not, you know, as far as I was concerned, all I wanted him to do was remove his fixtures, his, you know, his desk, his, you know, his display fixtures, you know, just to walk out and leave these, you know, these, and not only that, maliciously dump everything right on the front deck. Like we had tons of dirt deposited on the deck from all of his pots that he had sanded. It was just way over, you know, what I would experience. It was malicious. And that, you know, really came down to, you know, why would anybody do that?
Okay, let me go back to the plaintiff. Did the plaintiff act in a malicious way? Could you respond to that?
Yeah, absolutely not. We abided not only by our prior lease, but also by the terms of this early termination release agreement. The sand and the materials that the defendant's referencing was actually a result of the damages he caused prior to us requesting the termination. Our business, I'm not sure if you're familiar with it. We were on the corner of Hilltop and 22. We had a lot of outside displays and fixtures. And part of that, we had large plastic flower pots filled with sand and other material to put garden stakes in. The defendant and his employees had removed garden stakes from these without authorization. They tried to reinstall the garden stakes. They broke the plastic pots. And that was all summarized in the invoice that he was presented with and failed to pay, which precipitated this negotiation and our entering of this agreement. So no, there was no malicious activity. We abided exactly by the terms of our agreement.
Okay. I find the agreement to be binding, and I'm going to award a judgment in the amount of $1,000 to the plaintiff in this case. Unfortunately for the defendant, when you have something in writing, that usually binds. And I think it covers any concerns that the defendant has. And I wish you both well. I don't know either one of you, but you both seem like good people. And I hope going forward that you both have good lives. Okay. Thank you very much for being in my court today. Sorry to disappoint probably both
Thank
of
you, sir.
So thank you.
If I may ask a clarifying question, just sorry to interrupt. In regards to the court.
Plus court costs. Yes.
Thank you. Okay.
Okay. Thank you both.
So
Good luck to you now.
how much is that? $1,000.
$1,000? How much is $1,000?
No. What additional? What are we talking about?
$82 for court costs.
So $1,082?
Yes.
Okay.
Let me double check that, but I believe that's correct.
I think the service fee was 36 and
we have 82. So
okay.
So $1,082. So
all right,
sorry to disappoint both of you, but good luck to you both.
Disappointment.
Okay?
You know what? I'm not disappointed. I'm just disturbed that people wouldn't abide by, you know, agreements that, you know, are verbal, the right thing to do. That's my biggest issue here. The money's not the thing. It's the principle of it.
There was also a written document that takes precedence. And you know, there's an old saying,
like I said, was done under duress, and you know, that's you know, it was the time that it all, you know, exploded, and I was trying to just terminate.
You're welcome to your opinion. I guess and the plaintiff is welcome to his opinion, but I'm also welcome to mine. That's why I've decided. I'm sorry to disappoint you, sir. And you know, a written document is binding in the courts. In an oral agreement, there's an old saying: an oral agreement is worth the paper that's written on. So, good luck to both.
I get it.
Appreciate it. Thank you for your time, Ron.
Bye now.
Goodbye.
Thank you both. Good luck.
Goodbye.
Bye now.
Okay, Jay, you still there?
Yep, I'm still here.
Okay.
I'll text you our address if you want to issue a check.
Yeah, I would appreciate that. Thank you.
All right, thank you. Goodbye, everybody.
Okay, bye now.